Massachusetts. Court is open. Please be seated.
Good morning, everyone, and welcome to the Appeals Court. I am Chief Justice Amy Blake. I am joined on the panel today by Justice William Meade to my right and Justice Gloria Tan to my left. We are the panel that will be hearing all 6 cases on the list today. I know most of you have been here before, but just a couple of ground rules. Each side is permitted 15 minutes of argument. There is no rebuttal. We will likely take a brief morning recess after the 3rd case. I can assure you that we have read all of your materials, so you should use your time wisely and get right to your arguments. With that said, I will call the first case, Commonwealth versus Owen R. Broadhurst, docket number 24P766. Good morning, counsel.
Thank you, Your Honor, and may it please the Court. I will start with my second argument first, which is the argument concerning the prejudice that resulted to my client from going to trial with a conviction which was later vacated, still hanging over his head. He went to trial in 2018.
Can I ask you a preliminary question about this argument, though? Was this raised below?
The argument that he should not have gone to trial? No, it was Hallahan.
Why not do a motion for new trial below and then, depending on that, come back and see us? I don't know how we unwind this at the appellate level.
It's an unusual case because you're on direct appeal. At the time of his trial, Hallahan had not yet been decided. I don't think it had even been briefed.
So you could have moved for a stay here, asked for leave to file a motion for new trial below. I don't have a crystal ball, but I'm guessing we would have said yes, please, because we'd like that answer below before we tackle it.
Yes, we could have done that, but because it's on direct appeal and because, in our view, there's no reason that he should have to go through a motion for a new trial, we believe that this court has the power to act immediately. A motion for a new trial would further delay the proceedings. It would involve yet another appeal. You know, in this particular case, we have to go back to Hallahan, in which the Supreme Judicial Court found that a defendant who was the subject, of a certain type of breath test was entitled to a presumption of egregious misconduct.
But Hallahan came up through a 30B motion, right?
It did.
We don't have that benefit here.
No, you don't, but...
And it was supported with affidavits that provided a factual basis for the claim.
Understood.
You say in your brief that he was hamstrung in his at a trial, but there's no factual basis for that. I mean, you don't even explain it in your brief.
Well, I believe I do. The factual basis for it is, as any trial lawyer knows, going to trial with facing a second conviction puts you in a very different spot than if you're going to trial having no OUI conviction. This court can recognize that as a matter of law and simple common sense. If you don't have a conviction...
But how does that hamstring your defense?
Because it hamstrings him both in terms of his plea and in terms of what he's facing at sentencing.
Well, it definitely affects sentencing.
Yeah,
But your goal is to get him acquitted.
yes.
So it doesn't matter if he has a prior offense. The jury's not going to know that.
Jury did not know that, but on the other hand, he was in a position where prior to trial, there was always negotiations, always discussions, and as I point out in the reply brief, most cases are disposed of by quaff if it's an initial drunk driving. In this case, because it was a second, he's not in a position to negotiate for that. So the way I would look at it, Justice Meade, is, again, you have to go back to Hallahan. We're saying there's a presumption of egregious misconduct which affected his prior conviction. He goes to trial with that conviction hanging over his head with both a difficult plea position as well as one that, as Justice Meade, as you just point out, does affect his sentencing.
But Hallahan, though, and the SJC said there was a presumption of government misconduct, but not a presumption of prejudice here. And Justice Meade indicated we don't have an affidavit from the attorney or from your client, which is what you had in Hallahan, right? So is the record sufficient for us to,
I believe it is, because in this case, in other words, what you have to decide is you have a prior conviction with which was clearly the result of prejudice. We moved to vacate that prior conviction. The Commonwealth did not oppose that motion, and his prior conviction was vacated. And this all happened before the direct appeal, or while the direct appeal was pending, I should say. We had sought a stay in this court to allow that process to occur. So the question is, can you recognize prejudice where someone both faced a more severe sentence and was deprived of a potential 24D disposition, or at least unable to negotiate it in the circumstances that he was in? And you're correct, Justice Meade. I mean, we could go back, submit affidavits, but the affidavits would say something along the lines of, I wish I had had no prior conviction, so I would have been in a better position to decide whether to go to trial or not, negotiate for a 24D, and certainly not to face the enhanced sentences.
Well, ideally would have known what trial counsel was thinking, too.
Understood. But I think in this particular case, because you're on direct appeal from a conviction, which I think, in all candor, any lawyer who's going to trial on a operating under the influence charge, you don't want a first conviction on your record. That is.
This was a motor vehicle accident, though, right? He rear-ended her?
Yes. And so, and again, 24D, I'd admit, is discretionary. So, there's certainly no guarantee that he would have gotten that. But it's still, he's in a position where he has a conviction that he shouldn't have had. And that puts you in a more difficult position, I think, as a matter of law, as a matter that this court can recognize without the affidavits from the attorney saying, I would have had a better time without it.
It would have been interesting to know what the Commonwealth would say, because he was also convicted of negligent operation, and there was injury to the victim, right? It would have been interesting to know whether that's something the Hamden DA's office would be likely to quaff or agree to a quaff.
I think it depends. I'll let my friend speak for himself. But it depends on, to a certain extent, the extent of the injuries. I don't think the injuries are severe here.
She had a concussion.
She had a concussion.
There were children in the car.
It was an event that caused some harm.
Not a fender bender.
I fully concede that. But, the question still is, he's got a conviction hanging over him which has later been found to be an invalid conviction based on, again, the misconduct. And it's important to recognize how strongly worded Hallinan was.
There's no direct Hallinan problem with the case that went to the jury, though.
No, there was no direct Hallinan problem with the case that went to the jury. That's correct.
What about the refund that you're seeking? Has this court ever granted a refund on direct appeal without having been moved for below?
No, I haven't seen that. On the other hand, I think the case in which the Supreme Judicial Court laid out the procedures, it certainly leaves it open. And while on remand, we could go back and seek that.
We don't have a record for this, do we?
You don't have a record.
We don't know what he paid, the Commonwealth makes an interesting argument that we don't even know if the fees that he paid would have differed from a first offense versus a second offense.
That is true. On the other hand, I think we're not asking the court to calculate those fees. All we're saying is that if the court were to, in its decision, say that to the extent that any fees were based on it being a second offense, those should be refunded. I think that would provide some guidance and would get us past at least that hurdle with respect to when we go back to the district court.
but the procedure outlined in Martinez states that you should file it in the trial court, correct?
And I think that's correct, but I don't think it precludes the court from issuing a general order saying that because this should not have been a second offense, any second offense-related fines or fees should be refunded. I think that would be helpful to my client going back to the district court. And it's certainly something that I think the district court would obviously have to take notice of. So that's all we're asking for. Just again, to make a couple of points, as you pointed out, Justice Meade, under Section 24, there's a gradation of penalties, starting with a first offense. I think it goes all the way up to a fourth or fifth offense. If we have to go back for a motion for a new trial, that is discretionary with the judge. Were the new trial on the second offense to be denied, we come here, yes, I agree, with the advantage of a record, but we come here also with a standard of review that's abuse of discretion, which is a heavy load for an appellant to carry, which is...
You filed a motion for resentencing, or some defense counsel did on this defense. What happened with that?
I'm sorry, say again?
There was a motion for resentencing that wasn't acted on.
Yeah, I don't know the answer to that.
That would have answered a lot of the issues you're raising today, wouldn't it?
It might have, but it wasn't. I don't believe that the motion for resentencing was in the first case, the prior. And I think the Commonwealth was communicated, and this is not part of the record, the Commonwealth communicated some discomfort with that. What was ultimately resolved between the Commonwealth and counsel below, who was appointed to argue the request for resentencing, was that they would simply withdraw the admission which followed the second trial, the admission that it was a second offense.
Oh, all right. I think maybe I misunderstood. I thought it was related to the second offense.
Yeah, I think it was the first offense.
Okay.
And so that's where we are on that. Why are we here? He's already been sentenced. He's already served his sentence, not only because of the fines, but now he has a probationary disposition on his record. Now, I think the trial court was generous in that sentence, could have sentenced him to time, did not do so. But on the other hand, it's still a conviction, as opposed to if he were to get a new trial and go back and be able to work out a disposition, he has a quaff on his record, as opposed to the felony conviction or the conviction for the drunk driving. So it makes a difference to someone who's still working and active.
I'm sorry to go back to this, but I was just checking while you were talking with Justice Meade. Record 29 says the motion for resentencing was in this case.
There was a motion for...
It was filed in March of 2025.
Yes, it was in this, and I may have misspoke. It was in this case, and I think the motion for resentencing was something that there was...
Trial counsel asked that he be resentenced in this case as an OUI first offense.
Yes.
And no action on that motion?
District court did not do that, and then the counsel below...
When you say didn't do it, they didn't deny it, they took no action?
Took no action because a subsequent motion was filed to withdraw the admission to a second offense. And that...
And we here at the appeals court stayed this case to find out whether the motion for resentencing had been filed and to give new counsel the opportunity to consider leave to file another motion for resentencing. So we did stay this case to get that answer, and then it just didn't go anywhere?
Well, it was the counsel below filed a motion for resentencing. She then subsequently filed a motion to simply withdraw the admission to a second offense, which was...
Right, but our stay was directed to you as counsel to give you, new counsel, a given leave to file and the trial court given leave to consider a motion for resentencing.
Right.
That's at record 32. You did not pursue that. I just want to be clear.
Counsel was appointed in the district court. I was not...
No, this is on the appellate level, counsel. Your name is all over this motion.
Yes, but I did not, on the motion for resentencing, he had another attorney. My appointment does not cover appearing in the district court. And he had a second attorney. That attorney negotiated with the Commonwealth. The Commonwealth was uncomfortable with a motion for resentencing for reasons that they can explain. She decided with my client to simply
Not to pursue it.
and to pursue a different motion, a motion to withdraw the admission
Just so
to a
much.
second offense. So the counsel below in the district court made that call. And that's where that was. So in conclusion, I won't touch upon my first argument. The counsel points out correctly that there was a fair amount of evidence of intoxication, but given
You're not conceding that issue, are you?
I'm not conceding that issue. I am acknowledging what the record shows. I'm not conceding the issue because of the importance of scientific evidence and the way a jury would credit that.
Understood. Thank you very much. Mr. Lynch?
Good morning. May it please the Court. Travis Lynch for the Commonwealth. Starting with the second group of issues.
Before we get there, can I just quibble with you about something in your brief? Well, I
Okay.
am going to quibble with you, but I'm not going to ask you. I'm going to quibble with you.
Sure.
The horizontal gaze, it was preserved. I don't understand why you said it was unpreserved.
No, well, after, there's no motion to strike. The testimony came in.
Yeah.
An objection doesn't preserve,
And then there's a motion for a mistrial.
yes.
So you think that he needed to also say move to strike?
Well, there's actually two different issues here. There's the question about whether the judge needed to declare a mistrial. There's a subsidiary argument complaining that the judge did not also strike the testimony formally.
Okay, so do you agree, though, that under either standard, the result is the same?
Do you mean whether the evidentiary objection is preserved or not? Is that what you
Yes.
mean?
If we're reviewing for prejudicial error or substantial risk, do you think the result is the same?
No, I mean,
Do you win one and he wins one?
no, the Commonwealth wins on both grounds
Okay,
because of the
thank you.
overwhelming evidence of
Why
impairment.
don't you move on to the other issue?
Yes. So with respect to the Hallinan issue, I think it's as simple as saying we don't have an adequate record to address any of these issues. The Hallinan issue is always raised by a motion for new trial because we don't have a factual record to say that the defendant is prejudiced. We agree that there's a presumption of, in the underlying OUI, the first case, we conceded that there was a problem there. And so with respect to that prior offense, there's a presumption of misconduct as to the existence of that, prior offense. But there's no presumption of prejudice. We have no idea on this record how trial strategy was affected. You can't just say that on appeal. I would also note that, as was mentioned several times during this argument, the fact that the defendant has a prior is not part of the trial record of this substantive offense. That's the consequence of the bifurcated trial structure required by statute. And we don't know on this record what the Commonwealth would have done if the defendant had only a first offense. It takes two to tango on a plea negotiation. We don't know in this posture what the Commonwealth would have done. I was not trial prosecutor. I wasn't even practicing at the time of this trial.
You had a BT, but you didn't use it.
That's correct. So,
This was pre-Hallinan.
so it was pre-Hallinan. So if I can, outside of the record, the DA's office had stopped using, our office had stopped using the BT sometime in 2017. So,
On Justice Brennan's decision?
yes.
Gotcha.
So before, there's a 2017 decision in Ananias, and then there's a 2019 decision. At some point after the 2017 decision, we stopped using the breathalyzers. So there's a significant period of time in Hampden where we had, the police were administering breathalyzers, but defendants weren't going to trial. The Commonwealth had stopped using the evidence in Hampden at that point. So there's no breathalyzer coming in this trial. So this case is not actually affected by Hallinan, the underlying offense. again, we just don't have a record to evaluate these claims. With respect to the Martinez refund issue, we also don't have a record. And this is not to say that the defendant can't just file a motion in the trial court. This is not a court of first review. You can't decide this issue on this record. So because the defendant can just file the motions, I don't think the court, there's no decision of the lower court for you to even review. Unless there's any additional questions.
Does he have to be resentenced, though? Assuming we affirm this conviction, does he still have to be resentenced?
Well, I don't see how, if you view the fines and such as part of the sentence, then I suppose that's possible, but it seems as though that's really Martinez refunds. He's already served his probation. The sentence is otherwise fully executed. There's nothing else. With respect to the probation, there's nothing we can do now. This appeal entered years after the defendant had already served all of the other components of his sentence. And
is it indicated on the docket that it's a conviction for a second offense?
Well, I think the effect of the motion to withdraw the admission to the subsequent offense caused the record to now reflect that it's just a first offense conviction.
So if there was a third offense, the look back would just indicate that it's really a second offense because the first offense was vacated.
I'm sorry, I'm not sure I understand.
If he were to get convicted again, it wouldn't be a third offense, it would be a second offense.
The next one?
Next one.
If there were, let's hope there isn't one,
Yes,
but
of course.
yes, correct. Yes,
And you fixed the breathalyzer.
yes.
Mr. Lynch
As far as I know.
specifically did.
Well, I'm sorry.
Andy.
As far as we know. So, unless there's anything else, I'd rest.
Don't see any other questions. We'll take the rest of your argument on your brief. Counsel, thank you
Thank
very
you.
much. Our next case is Commonwealth versus Jean-Jeffrey VILNO, docket 24P677. As counsel approaches, I just remind you that this case is partially impounded, so please do not use any victims' names.
May it please the court. My name is Attorney Carl Suchecki, and I represent Mr. VILNO here today. In this particular case, we saw reversible error in the closing argument by the Commonwealth. The misstatement of the evidence is specifically what we're talking about. I'd like to go through the give and take between the investigator and the prosecutor during direct testimony.
Before you get there, can I just ask you, do you agree or disagree with the Commonwealth's sort of breakdown at page 29 of their brief as to what is preserved and what is unpreserved? Is there any challenge to that?
I'd have to get back to you because I don't know what page 29 is on the
Okay.
brief.
Do you agree that there are some that are unpreserved?
Well, there's some that would be under substantial risk and some would be the
Okay.
prejudicial error. And this particular issue we're talking about was objected to. During
The debit card identity theft
yes,
question?
the credit card, the debit card, yeah. So in this particular instance, when examining the detective, the prosecutor asked a series of questions, and the questions are phrased in such a way and answered in such a way to give a certain impression. And when the prosecutor asked, was there a time when Mr. VILNO was spoken to, and as you go through the give and take between the prosecutor and the detective, it's very clear that she's trying to get out that this card was taken from Mr. VILNO. The impression given on direct is that the detective himself got the card from Mr. VILNO, but that was not the case. What happened on cross-examination was that was taken apart. When he said, she asked on direct, during the conversation, were there items retrieved from Mr. VILNO's person, implying that the detective had taken it from Mr. VILNO himself. But that's not the case. When on cross, he said he didn't know who it came from. He got the card from somebody else. So essentially, everything he did was secondhand, but the impression given on direct was that it was he who got the card from Mr. VILNO. In fact, he conceded that he didn't know where the card or the items that were retained came from. He didn't know who the officer was. And then furthermore, after that, they did no investigation. It was just an inert card. And that card became a very pivotal piece of this case because it's a trafficking case. They're trying to show a financial relationship that Mr. VILNO was controlling her, and this card, it was really just a really key piece for the prosecutor in her closing argument. And during her closing argument, she says repeatedly that this card, and I'll go through the actual quotes, but the whole point is that the impression given was that this card was proof that Mr. VILNO was trafficking and that he had control over her with this card, or repeatedly, this card, that he took her identity, and there was a curative about the identity part of it, where the judge said, well, no, not but the fact is if you look at it, and you look at the testimony and the cross, this was just an inert card with no investigation. Everything that was said about that card was just fabricated. It was not reality.
Well, the prosecutor was asking the jury to draw an inference.
Right, a fair inference.
I'm not done. She was suggesting that the card was his based on the circumstances. The great level of control that he exercised over the victim, every aspect of her life, she never got any of the money, he got all of the money. The fact that the name was spelled incorrectly on the card, why would the victim have this is one of the rhetorical questions, but the point is the same. Why would the victim carry around a card with her name misspelled on it? And most importantly, and perhaps compellingly, the evidence showed that she had left maybe 3 months before, and when they found this credit card on him or near him or whatever. Why would he be in possession or near the connection to this card?
Well, she was a tenant in the building, so it's quite just as possible that she left the card there and was picked up by somebody.
Right.
But there's nowhere does it say.
See, what Mr. Selchecki, what prosecutors do is they ask the jury to draw inference based on the evidence that shows guilt, not that it shows non-guilt.
But it has to be a fair inference, and this card was found. This card doesn't. Just the fact that there is a misspelling in a card. I have a difficult last name, and I often get credit cards in the mail that have it as a misspelled credit card. Doesn't mean that somehow somebody's committing fraud. It just means that there's a credit card, just a credit card.
Wasn't part of the defense theory here that this wasn't sex trafficking? She was a highly intelligent businesswoman, and if that's the theory of the defense, the fact that there's a credit card with her misspelled name goes wholly against this fantastic business person.
Why would it have anything to do with that? It could very well have been her card, and she just got a card in the mail that had a misspelling in the card. Nobody tied the card to Mr. VILNO.
And as this really wonderful business person, she wouldn't call the credit card company and say, hey, I'm a high-level business person, you spelled my name wrong on my credit card?
Well, I don't know about high-level business person, but in this particular instance, nothing ties Mr. VILNO to this card. Nothing ties her to the card, really, except that her name, and it's misspelled on it, so it may have been her card. She could have very well, as we posit in the brief.
Was part of the defense that she was a businesswoman who was running an online business prostituting herself? Was that the defense?
The defense is, Your Honor, that yes, she came to this knowing what she was getting into. She put an ad on WhatsApp herself, and that she had drawn the attention of Mr. VILNO, and Mr. VILNO gave her the attention and proceeded to go forward. But in this...
And in your, not you yourself, but the defendant's closing argument, there was, at transcript 3, pages 48 and 49, a lot of discussion from defense counsel about this credit card, right? And the prosecutor's entitled to respond to that, no?
We're still going with the fair inferences from the testimony and the evidence. And just because the defense counsel may have said something about it being in possession by Mr. VILNO, again, that's not evidence. They also gleaned the same bad information from the testimony that the prosecutor rather artfully drew from the detective on direct. And there's no evidence that this card had anything to do with Mr. VILNO, zero. There's no evidence that he had any access to this account. There's no evidence that he drew money from it. There's no evidence that he had it for or was carrying around the card on his person and had it for 3 or 4 months. What the evidence was that the card was found in the unit after she had left, but that doesn't mean it came from him. So the inferences that she does, not just once, but repeatedly, and circles back at the end and points out that this is really the linchpin of the case, is that somehow Mr. VILNO controlled her finances, and this card was indicative of that. And she drew that out on direct. Defense counsel tore it apart and said, well, there's no investigation on this card. Did you see was it even an active card? There wasn't even proof that it was an even active card. It could just be a card that came in the mail and nobody used it.
Like your brief, you say that maybe it was because she worked at Dunkin' Donuts. I mean, that's as much speculation as you're arguing the Commonwealth has made.
Right, but except for the fact that when the defense says it doesn't impact the case, and it doesn't. And this is so prejudicial that it doesn't impact the case. And when the jurors hear testimony that this guy has a card, he's running with it, it's in his pocket, and he keeps doing it, and he controls her. She says something about.
Right, so I know this is hard. Pretend you're the prosecutor. What is a reasonable inference from the facts of this card, where it was located with the misspelled name? What's a reasonable inference from that?
I don't think you can make any inference. I think this card should not have come into evidence. It had it was inert. Nobody proved anything about that card. It's just a card. Somebody found a card with her name on it. She's not associated with it. There's no
Credit card or a debit card?
A debit card. But nobody's proven it's even active. Anything was withdrawn from it, that she withdrew anything or she withdrew anything. There's no information about it whatsoever. But that didn't stop her in closing argument to say that, oh, this is proof that this guy's been running her and this is her card. He controls her. She said something about credit bureaus. It's affecting her credit. Wholly out of whole cloth. She didn't even, and that's for a credit card, but there's no proof from the credit bureaus or anything that validates that. It's pure speculation. And a prosecutor cannot speculate, can only make fair inferences, and it's not a fair inference based on the evidence that she herself drew from the detective and then the cross-examination. The evidence is that this card had nothing, no investigation on it, no proof of anything except that a card was found, period. And the police officer that they had up there, the detective who they questioned, didn't even know where the card came from, who it came from, how he got it. And the implication, of course, was the prosecutor was desperately trying to prove is that it came from Mr. VILNO, but that wasn't even proven. But she uses that inert card with no evidentiary value and tries to weave a tale during closing argument, and it's not a fair inference. It's very prejudicial because it goes to the heart of the case. And there are four particular items you have to prove in order to prove that it's enough to reverse the case, and this case meets it. What first was it seasonally objected to? Yes. Whether the error was limited to collateral issues? No. It went to the heart of the case, the trafficking. The instruction that the judge gave went only for the identity theft. But if the judge had his ears on, or actually had the real gravitas of what the actual evidence was it didn't prove anything. The detective on cross said there was no investigation. There's nothing to this card except that it was found. Period. And the judge got it wrong, and the prosecutor got it wrong, and even though he's an excellent judge, he also, bought that this somehow was related.
Can I ask you, in the defendant's closing at trial, I believe it's at transcript 3, pages 48 and 49, doesn't defense counsel say the card was retrieved from the defendant's person?
Yeah, and it's the same thing as I said. He's also, obviously it's not evidence, and it's not a concession. He's just.
I understand that, but I'm just.
But the fact that he says it, to me, says that he has also listened to the testimony of the detective and bought into it, but it's not evidence, and the real evidence in trial is it's not there. There's no possession. Nobody's proven this card has anything to do with Mr. VILNO.
Detective Aiken says he took the card from him and then corrects himself and says that some other officer handed him the card.
That gave not VILNO the card. Somebody gave it to the officer, but he didn't know what officer.
As far as you're concerned, where did the card come from?
It doesn't matter. It's just a card. It's a card with a person's name on it.
It's not my question. Based on the record, where do you think the card came from?
What I think of where the card came in really is
The
invalid.
officer testified when they arrested him. Akins first says, the card was on his person, and then he said, oh, it was another officer who gave me the card.
It wasn't a no. This was very artfully done in such a way to imply that he actually got the card from, not only the card, but several items from Mr. VILNO himself.
If they wanted to be artful, they would have said the other officer took the card off the defendant and gave it to me.
I think that there's an attempt at that implication in what was just said. I think they tried to imply that, and he tried to imply that in what you just said yourself.
But you've told me no other origin for this card.
It's not my, obviously, that goes to rhetorical questions. It's not the defendant's burden of proof to prove anything.
No,
the fact is that...
But inferences from circumstances only need to be possible.
Yeah, but you got to be fair. You can't just take a card and say, this card means this. It doesn't mean anything. It's a card. And you have to have something more than somebody just saying that...
It means plenty.
You're trying to get and they're trying to prove they're a very essential part of their case, which is trafficking. And when they're trying to prove trafficking, that he ran her and this card had anything to do with it, and they didn't prove that. They didn't even prove Mr. VILNO had anything to do with it. And they can't even prove that Mr. VILNO gave the card to them. All they have is a detective getting up there saying he got the card from somebody on cross, that he got the card from somebody else. He didn't know who he got it from. He didn't even know when he got it.
Wasn't it when he was arrested?
I have no idea. I have no idea. And it's just not even clear on the record. So if you go through the four criteria for reversible error on misstatement of evidence, this is a misstatement of the evidence. And if you look at the evidence, it's not there. They did not prove that this card had anything to do with Mr. VILNO, had even anything to do with the complainant, except for the fact that a card with her misspelled name, but it's not an active card. They didn't prove it was an active card. It could just be a solicitation in the mail with a misspelled name. Everybody gets solicitations in the mail all the time with phony bank cards or whatnot. So the Commonwealth has to prove their case. And they try to imply that they proved it with this card, and this card had no evidentiary value. And it should not have been used the way it was used in the closing argument to prejudice the defendant and somehow say it had anything to do with the charges brought. It's a card. They found a card after the fact with other items, and the other items in our closing argument have to do with sympathy, rhetorical questions, and vouching for the credibility. I'll rest on my brief on those. But really, Mr. VILNO got an unfair trial because the linchpin of this case was trafficking, that he was running her, and this card meant a lot because if you read the closing argument, the prosecutor very clearly says she's circling back to the card to prove her point, and her point was that Mr. VILNO was trafficking this woman, and that's error to say that card, which they didn't prove, had anything to do with it.
And we're going to leave it there. Thank you.
Thank you, Your Honor.
Attorney Burbine?
May it please the Court, Carolyn Burbine for the Commonwealth. It's our position that the prosecutor did not misstate the evidence or make any of the other errors alleged by the defense.
Was there evidence that the police officer got the card from another police officer?
Yes. My account of it indicates that Detective Aiken testified that it was retrieved from the defendant's person by another officer in March of 2019. So I would...
Is that when he was arrested?
I believe so, Your Honor. So defense counsel was the first to bring it up in his closing to say that while there may have been a credit card in his possession at that time, but it did not, with the misspelled name, but he wasn't charged with larceny of a credit card, so there's no indication that he took the credit card from the victim. But
so how do you respond to the defense argument here that there really was no nexus, this was unfair inference based on the record and the evidence that was presented, and this was just a card that a misspelled name?
Yes. Well, I would say that, again, we can ask a jury to make reasonable and possible inferences. They don't have to be necessary or inescapable, and here that's all the prosecutor did. There was evidence that he had set up the work phone from the victim with the apps. She testified he had her personal information. The misspelled name raises the question I mean, if she.
What does that indicate, do you think? the
I
misspelling?
think if I set up a credit card and it came misspelled, it's a common sense inference that I would get that corrected. And the fact that she doesn't have the card, he has the card. And the fact that she says he ran the business, he set it up, I don't think it's a leap. I think it's a reasonable inference that he set up a credit card in her name and he carried it. He controlled the business. He purchased items perhaps with it or set up an account with it.
But we
and it was a debit card.
we don't know that.
No, I'm sorry, but I just think these are inferences. So
But wasn't there some sort of forensic investigation of what the card was used for?
they didn't do one, and I can't say why. It's not in the record. But I don't think that the prosecutor went beyond the pale to argue that the fact that he still had the card in his possession 3 months after she was gone, it was a misspelled name, which could indicate that he was the person who applied for it and didn't know how to spell her name correctly. And he still has it, and he's in his possession on his person, not in a drawer somewhere, or, I mean, I don't know. I don't think that it's not a reasonable inference to say, can't we infer that he's still using it because he's carrying it? It's on his person. But even if, this court were to disagree, you have to look at the jury instructions as well. And the fact that there was other evidence in this case that linked him to this phone, to controlling her, to running the business. So I would say that this credit card evidence in the closing was not the linchpin of the Commonwealth's case. The Commonwealth kept directing the jury back to the evidence, which was the forensic evidence from the phone that showed his links. Bluetooth is linked to that phone. He's linked to that phone by his name. The photographs look like more than one person probably took those photographs. There's 2 sets of hands in the photographs. There was all kinds of other evidence linking him to this phone, him to running this business, and we have her compelling testimony as well. And I would also ask the judge, this court, to look at the jury instructions, preliminary instructions, instructions just before the closing, final instructions. Closings are not evidence. This is what evidence is. Closing arguments are just the parties giving their explanations. They're urging you to make inferences. Inferences are explained. So I would argue that even if this court were to find that any of these statements were excessive, the jury instructions would have cured any error. Did the court have any questions on the other issues raised about the closing argument?
I don't see any. We're happy to take the rest of your argument on your brief.
Thank you, Your Honor.
Thank you. The case is under advisement. Thank you, counsel.
Thank you.
Our next case is Commonwealth, and I'm sorry if I mispronounced this, versus David Antonetti-ALMESTICA, docket number 25P183. After this case, we'll be taking a brief morning recess. Hello, Mr. Shea.
Good morning, Your Honors. Richard Shea for the defendant, David Antonetti-ALMESTICA. The direct appeal is combined with denial of a motion for new trial. The only issues raised in that motion for new trial, which was denied by the trial judge after an evidentiary hearing. The principal issue is the admission in evidence of testimony and exhibits concerning the arrest of the defendant in Springfield. The fatal stabbing in this case occurred at 6:30 in the morning on October 4th, and the police determined that the defendant was the suspect in the case, and they pinged his phone shortly after they got that information late in the morning, and followed the ping as it went to Springfield to an attorney's office that he was consulting, and ultimately to a house nearby. And a team of state and local police were assembled. and went to the house. They observed the Jeep with the knife and the shoe in it, and the defendant was arrested in a bedroom while he was apparently under the influence. The Commonwealth, with respect to the defendant's arrest, did not produce any officer who actually saw the knife which is in question. Officer Cackley stood in the door of the bedroom and didn't see any knife. He was the cover officer. There were two other officers, a state lieutenant and a Holyoke police officer, who did the arrest, and they were not called. Who was called was Trooper Noah Pack, who was standing outside. He was the evidence officer, so evidence was being brought to him, and it was through him that the Commonwealth got into evidence the fact that there was a knife in the bedroom, and they tried to tie it to the defendant. The defense attorney did not file a motion in limine to exclude either the knife evidence or the Jeep evidence, which contained unrelated knife and shoe with blood on it.
But there had there not a prior motion in limine to exclude certain evidence that I think he called it maybe consciousness of guilt evidence, and the judge allowed some of it in and excluded some of it?
No, I think he denied the motion outright. If you read the transcript of the hearing and the motion itself, what was argued about principally was that he was going to Springfield to consult an attorney, and that was
Right.
some protected conduct, and it shouldn't be brought forward as consciousness of guilt. And there was not brought up at all.
I thought, maybe I'm wrong, that there was a motion to exclude what I'm going to call everything that happened in Springfield.
Right,
The trial counsel had filed,
right.
right? And then on the motion for new trial, he essentially explained that he thought, based on that ruling, it wouldn't necessarily have been successful, particularly where your client did not have an expectation of privacy, at least in the Jeep. There was I understand the Monday morning quarterbacking, but there was a strategy for why he didn't file the second motion that you're saying he should have filed.
Well, that's what I say is clearly erroneous for the judge to have found that there was a strategy.
Well, the trial counsel did give 4 reasons why
He did.
why he did not. So a failed strategy isn't necessarily ineffective assistance.
It wasn't, I interpret his testimony in one way, which is he filed the motion in limine generally to exclude the evidence concerning Springfield. When that was denied, he did not think to file a motion in limine to exclude the Jeep or the knife.
Because he knew that they weren't relevant, and he was going to use that with the defendant's testimony to illustrate that the police were just trying to pin this on him with evidence that doesn't relate to him.
Well, yes, well, that was the cases dealing with the admission of knives and guns into evidence that are unrelated to the defendant were all cases where the defendant did not have, there was no basis for linking the knife or the gun to the defendant. So therefore, it was error to, over motion, to allow into evidence that kind of testimony.
Let me ask a more basic question. Is the conclusion that there was a strategy, is that a finding of fact or a ruling of law?
Well, it's mixed together.
Because he did have a strategy.
Well, his strategy was
That was a question,
his
actually.
strategy was to file.
Excuse me. Did he have a strategy?
No, not to exclude on the basis of.
No, he had a strategy
Barboza
to
and
use the evidence that he deemed irrelevant to his client.
To blame Medeiros for the murder.
Well, he said the evidence was irrelevant, but it was prejudicial because this was a gang case, which there was a motion granted at the same time as the motion in limine was denied to exclude gang evidence. Nonetheless, the prosecutor brought in all this testimony about a Jeep that was not linked to the defendant until defense counsel stipulated that it was. And there's no evidence that he had been transported in the Jeep or that he had any connection to the items that were found in the Jeep.
And he used all of those
that
things.
was-
He used all of those things as part of his trial strategy.
After they came in.
Yeah.
He could have kept them out. And my point is
He
that
could have, but you're just Monday morning quarterbacking. He knew that they didn't relate to his client. He knew that the client was there and that his clothes were there, but he's not tied to the Jeep. He's not tied to the knife in the Jeep. It doesn't fit Fisher's description, I think, or Medeiros' description of the knife. And the sneakers, for God's sakes, are 3 sizes too large for him. He wanted to make the cops look incompetent, and that's what the judge found.
yes, but the jury was told in the process that of the circumstances of the knife and the Jeep, and there were 4 men standing around the Jeep. There was a weapon inside it. The house was next door. There was a knife found in the bedroom with the defendant, even though it wasn't properly linked to the defendant. So, yeah, sure, they got the knife in with no problem. That just came in unobjected to. So what this is telling the jury is that he was associated with knives and gang members. And what else would they think that he was doing in Springfield?
There was no allegation that he was associated with gang members.
There were. It was
kept
an
out.
inference. It was an inference that could be drawn by the jury.
Based on what?
Who are these men around the Jeep? Why is there a knife with blood and a shoe with blood?
Anytime there's a gathering of 4 people, it's a gang activity? There was a party at the house, wasn't there?
That was, there was testimony that there was a party at the house, yeah. But then he had a knife in the bedroom.
I don't see how that equates to gang.
The Jeep was the defendant was arrested in Dartmouth on September 27th, driving the Jeep. That wouldn't have come in except that it was stipulated to. If he's driving the Jeep and the Jeep is then out in Springfield, and he's going out to Springfield, and there's all these men around with the weapon inside, and there's a knife in the bedroom that he is arrested in, then there's people around him that are armed with dangerous weapons. And they tried to pin the knife directly on him, but if you read Trooper Pack's testimony on cross-examination, which defense counsel succeeded in doing, which he could have done in a motion in limine, that Pack really didn't know where the knife came from, but he did testify that he thought the defendant was wearing a sweatshirt when he came out, and that police would not have left a knife in a sweatshirt.
But counsel gets out the sweatshirt is an XL, and his client's is a size small.
They didn't, the Commonwealth did not say that it was found in the XL. They tried to make it appear through Pack's vague testimony that, yeah, I got this box of things, and one of them was a knife that was in a sweatshirt.
It seems he had a two-pronged defense. He had Medeiros as the stabber and a Bowden defense that the police had no idea what they were doing.
Well, the Bowden defense was, frankly, pretty thin, because the Bowden defense was the police had not adequately processed the apartment where the stabbing took place. His claim centered on a sweatshirt that was found in a box in a closet, and the sweatshirt had blood on it, and the criminalist did not take that and have it tested for DNA. But that counsel said incorrectly that that had been taken off by Medeiros and put in the closet. Medeiros testified he did not have a sweatshirt on. He testified that he put other clothes on, hung up what he did have on in a closet. The other witness, Fisher, did not, she testified that he did not have a sweatshirt on. So counsel was mistaken in making that argument. And if the jury was attentive, they would have realized that there was nothing to this. And anyway, the victim was stabbed in a way that it was just a nick to his heart, which caused the blood to be captured in a sac around the heart. And nobody knew, even Medeiros said, I didn't know he was stabbed. The defendant said he didn't know he was stabbed. The EMTs who treated him did not know he was stabbed. He was laying in the street until they took his shirt off and they saw stab wounds. So the blood, there wasn't going to be any blood, and none was linked to him in the apartment. The only blood that would have been incriminating would be if you found the defendant's blood mixed with the victim's somehow, but the defendant's blood wasn't found, the victim's blood wasn't found. It was all Medeiros' blood, which was to be expected, and because he was an addict, and he said a lot of people were coming in and shooting up, even though they weren't supposed to, in the apartment, so there was blood around. And then after the stabbing, he sent Fisher to clean up all the blood. And they tested bloody items throughout, and it was all Medeiros' blood, or one was Alex Gould, who we never heard from. I don't know what happened to him. He was an occupant of the apartment. So that strategy was really based essentially on nothing. And all the testing that they put in was essentially irrelevant. There was no, in Springfield, it shouldn't have been offered. And what it showed was not poor police tactics, but the prosecution wanted to bring that in. There was no good reason for the prosecution to bring in all that testimony about the Jeep and the knife. And
Mr. Shea, we're going to have to leave it there. Thank you very much. Attorney Gauthier?
Good morning, Your Honors. May it please the Court, Stacey Gauthier for the Commonwealth, Bristol County District Attorney's Office. It's our position that the defendant's motion for a new trial was properly denied and that his convictions should be affirmed. With regard to the first issue, defense counsel did not provide ineffective assistance of counsel when he failed to move to exclude evidence of 2 knives that were found to not be the murder weapon, as well as a shoe and a Jeep that were found in Springfield around the time of the defendant's arrest. Prior to the start of trial counsel filed a motion in limine to exclude what he called so-called consciousness of guilt. The motion—
That's all of the Springfield evidence.
Yeah, it focused, like the written motion specifically focused on the flight to Springfield and the meeting with the lawyer. So the judge heard argument on that at the motion in limine hearing the day before trial. He thought about it overnight, and the following day, the judge allowed the following evidence to come in, where the incident happened, where the defendant was picked up, and what he had on him. And the prior day, the Commonwealth had argued that he had a red and black backpack on him. But, I mean, the ruling was that what he had on him. So then at the motion for a new trial hearing, trial counsel testified that he had attempted to have the, quote, whole Springfield event excluded when he filed the motion. He testified that when that motion was denied, he didn't see a constitutional issue to move to suppress the stuff at that point. And then he said that given the amount of untested evidence and blood evidence that came back to John Medeiros, his theory was going to be that John Medeiros was the murderer.
Do we know from his testimony whether he specifically understood that his first motion covered the sneakers and the knife?
I'm sorry, whose motion?
The defense motion limine.
So
the consciousness of guilt motion.
So so the motion itself, specifically the written motion, focused on the flight to Springfield and the meeting with the lawyer. At the motion for a new trial hearing, he testified that he attempted to have the, quote, the whole Springfield event excluded.
And then the judge in his ruling said, we're letting in what was on him.
Yes, that's correct, yes.
And that would arguably include
the knives, right. And so, but he didn't, trial counsel testified that because of all the untested blood evidence and the evidence that went back to Medeiros, he was going to, pit it on Medeiros, so he didn't think to move to exclude the knives and the Jeep at that time because he didn't find, I would suggest that he didn't find it was relevant.
They weren't specifically mentioned, though, correct?
They were not specifically mentioned. That is correct, Your Honor. So I would suggest that, his counsel's theory was not unreasonable, given that the judge was going to allow evidence of what the defendant had on him when he was found, when he was arrested. And at the time, right up until, I guess, cross-examination, it was clear from, the discussions in the motion in limine that it appeared that the knife that was on or with the defendant when he was arrested, there was no nexus to that. It appeared up until cross-examination that there was a nexus between the knife that came to the police station with the defendant as well as the Jeep that had the other knife and the sneaker in it.
Why were you putting in the knife and the sneakers and the sweatshirt that weren't connected to the defendant?
Well, it appeared up until cross-examination that they were connected to him, at least the knife that went back to the booking station with him. As far as the Jeep, it would be to go, I would suggest to like a Bowdoin defense, to show the circumstances of the police investigation and that the police did an adequate investigation.
They knew from Fisher and Medeiros what the knife looked like.
That's correct.
And it wasn't a folding knife.
It was a folding knife with a plastic handle. And
Wait, which one?
It was
not the crack knife.
Oh, I'm sorry. It was the one that went back to the police station with him. That was a folding knife.
The Springfield knife was a folding knife.
It was a folding knife with the black.
And the crack knife was.
That was a folding knife with the plastic handle.
Okay.
But there was evidence that the police ruled it out as being the murder weapons. Both of those knives that were found in Springfield, there was testimony that the police ruled both of those out as being the murder weapon.
And the knife in Springfield is found with the North Face sweatshirt that's 3 sizes too big for the defendant?
That's correct. And at the time...
Why put that in?
I'm sorry?
Why did that go in?
Because the circumstances of his...
House.
It would be the circumstances of his arrest, and it appeared as though, from the police reports and the grand jury, that it was, it was like found on the defendant when he was arrested. However, it was through trial counsel's cross-examination he became aware that the trooper who booked the defendant, who wrote the report, he didn't actually know, specifically where the knife came from. Whether it was, in a sweatshirt that the defendant was actually wearing, or whether it was in a sweatshirt that the defendant grabbed when he left the house, when he had been in a room that wasn't his room, and, with clothes that weren't his clothes. So at that point, then counsel was able to use that evidence in the fact that we couldn't provide a nexus, and to make the argument that we were just putting the knives in to make the defendant look bad. However, prior to the cross-examination, it appeared as though we would be able to connect the defendant to the knives.
The judge found that there were other incidents or other evidence of the defendant's connection to knives. What was that other than the crack knife that Medeiros used?
So the other evidence would have been, again, it was the crack knife that was on the table, and then the defendant also testified that the knife that came with him to booking belonged to Hector Torres. He said he had seen the knife before and that he knew that it was Hector Torres's knife. He'd also testified, that he admitted that he was a drug dealer, and he testified that drug dealing is a dangerous business, although he denied that he carried weapons.
Dangerous doesn't mean knife necessarily, does it?
That's correct, Your Honor. But he, again, he had testified that the knife found in Springfield belonged to Hector Torres and that he had seen it before. And I understand that, there's a line of cases such as Barboza and Toro that putting in, weapons that are ruled out as the actual, murder weapon is, generally cautioned against. However, it's not like an unconditional disapproval of it. It could come in at the judge's discretion. I would also note that even if those knives would have been excluded had trial counsel objected, any prejudice I would suggest that flowed from that would be negligible. It was clear to the jury that the knife used in the murder was the folding knife on the table at John Medeiros' house. It was not a knife that the defendant brought with him. It was a knife that was grabbed off a table. Medeiros and the defendant both would have had equal access to it.
That wasn't recovered, though, was it?
It was never recovered, that's correct.
That's the one the little man came for.
That is the one, yes, Your Honor. The defendant, again, he admitted himself that he was a drug dealer. He admitted that drug dealing was a dangerous business.
Well, what if instead of knives, I know this is a hypothetical, not in this case, but what if it was guns? Does that change is it different because it's knives?
I don't think that it's different than it's knives. I think I believe Barboza involved a gun, and I believe that Commonwealth versus Marchetti involved a knife. So, again, there's still the general caution, but there's no rule that says you absolutely can't do it or the case will be reversed. Maybe a gun would be a little more helpful if it's if it's the same caliber gun that was used. But here, the testimony was that, it was a folding knife and a steak knife, and they were both specifically ruled out as being the murder weapon. And again, we were unable to link the defendant to the Jeep where the knife was found, and also we were unable to, link that knife that the defendant had at booking with him to him. From that, defense counsel was able to, to make the argument, again, a very aggressive argument, I would suggest, that the Commonwealth was only putting those items in to make the defendant look bad. And if there's no further questions.
I don't see any other questions. We're happy to take the rest of the arguments on the brief.
Thank you, Your Honors.
Thank you, counsel. The case is under advisement. The court will be in a brief morning recess. When we resume, we will hear the Department of Children and Families and others versus Father and Another.
Court is open. Please be seated.
Okay, we are back on the record. The next case is the Department of Children and Families and Others versus Father and Another, docket 25P755. The case is fully impounded, so please do not use any names. Mr. Como, when you're ready.
Thank you, Your Honor. May it please the Court. I'm William Como, and I represent the appellant father.
Actually, I'm going to stop you, and I apologize. The timer is incorrect. Mr. Como is 15 minutes, and Mr. Price and Ms. Kling will be sharing 7.5 each. So we're going to have a do-over in just a moment.
Thank you.
Are you ready, Mr. Timekeeper? Yes. All right, Mr. Como, if you would start again. Thank you.
Thank you. May it please the Court, I'm William Como, and I represent the appellant father. Before cross-examination of the second DCF witness on the first day of trial, the judge inappropriately asked the parents to reconsider the open adoption agreement that DCF had proposed. She highlighted her assessment that the parents hadn't engaged in services, there was still domestic violence in the home, and father had not benefited from the anger management courses that he had taken.
So can I ask you about that? Because I feel like something like that happens in some fashion every day in our trial courts, where judges are faced with dockets and they hear some evidence and they're trying to see if there's a way to resolve a case. And you didn't cite the case, and I haven't looked to see if the other side has cited it. The only case that I'm aware of, beyond TIA, where we have cautioned about statements pre-trial is a case out of the probate court called Prenovo. And I think that the pre-trial comments in that case, or at the beginning of the trial, somewhat suggested that the judge didn't understand that he had the authority to do something. So I've looked at TIA, I've looked at Prenovo, and I look at what Judge Shaw said in this case, and I can't get to where you are, so I need you to help me understand it.
Well, Your Honor, I don't know that it's a clear-cut case. I will certainly concede that. She didn't say you need to settle this case, but she certainly left no I guess, wiggle room to what she was looking for. She wanted this case settled. She pointed out
Well, she didn't want to. She just suggested that the parties may want to discuss,
Absolutely.
right? I don't think she at all indicated that this
No.
is something that she wanted to see happen.
That's correct. I misspoke. So she certainly did indicate that the case didn't look good for the parents, that because of what she reviewed in the record, and the lack of participation in services, the father's issues with anger management, that they should consider over the course of the break an open adoption agreement.
Which is certainly, in the grand scheme of everything available in the juvenile court, preferable to a full TPR, no?
Always preferable, unless, obviously, the parents are going to win the case, and then it's not. Father wanted a trial. He's entitled to a trial. He's entitled.
Then do we look at the strength, if we're thinking about that, then do we look to the strength of the case? And if we do, obviously the question about fitness, domestic violence, mental health, delusions, how do we balance? I get that he wanted a trial. I appreciate that. But we have to ground it in the evidence. And so help me with that.
Well, we have to give the evidence an opportunity to be heard first. You don't simply just read the record and say to people, I see the way that this is going. The father is entitled, any litigant is entitled to the presumption that the judge is going to be fair about this. Now, this judge in this case decided, without hearing from the father at all, which is different from Tia, at least in Tia, that mother had the opportunity to testify for a day and a half before the judge made her comments. She was heard. This father wasn't heard until after the judge had made these comments. And so, especially with a gentleman who may be suffering from paranoia and delusional disorders, I think it presents a question of whether he walked away believing that he got a fair trial. So, yes, there was a lot to say against the father, and I can't sugarcoat that. But the question isn't really that. The question whether it was
if it was just so compelling that nobody would make the same decision. And I think that's more of a jump ball. Because here, the judge, in her findings, made several conclusions that may have been made differently by a different judge who had not prejudged the case.
So you say conclusions. You're not arguing, you're not disputing any of her factual findings, correct?
That's an excellent point, Your Honor. I'm disputing the factual findings because they were conclusions. They weren't factual findings. They were conclusions that DCF had made reasonable efforts when the judge cited to no facts whatsoever to determine that they had made reasonable efforts.
Was reasonable efforts, though, specifically raised at the trial?
No, it wasn't. But every judge in every case, and you know, is required to determine whether the department has made reasonable efforts. Regardless of whether it was argued, it's a finding that a court must make.
But if you haven't raised it below under Daisy, I don't know how we can consider it here.
I'm sorry?
If it wasn't raised below under Daisy, I don't know how we consider it here.
Well, I can only point to two cases, Your Honor. The first would be the Tia case. That has no indication in it that the issue of the judge's prejudice had been raised in the lower court. Yet this court, the appeals court, did nothing except explore that possibility. The other case, about whether it was prejudged. The other case was the Georgia case, same judge about 8 years earlier, where they in fact pointed out that this wasn't raised below, and then they went on to consider it.
Well, I'm confused now, because my question was about reasonable efforts in Daisy.
Oh, I apologize.
The appellees make the argument that you never, not you specifically, father never objected at trial to the judge's comments, did not request that she be recused, did not move for a mistrial.
Right.
And they cite, obviously, LL Commonwealth, adoption of Leland, the petition to dispense with consent. So how are we viewing this claim? What is our standard of review?
It's de novo, Your Honor. And the reason it's de novo is because you cannot trust the findings of facts of a judge who may have been prejudiced against the party.
And what case do you cite to say that we're reviewing this de novo?
Again, I would go to Tia. Although it doesn't specifically spell out de novo, they state, and I can just find the exact language if you give me one second.
Stretching Tia.
Well, the considerations outlined above have accompanied our careful review of the transcript of the testimony and the exhibits introduced during the course of the trial. So they don't say that we explored the findings, that we didn't find that any of these findings were clearly erroneous or the judge made an error. They said we looked at the transcript and we looked at the record to make and the only conclusion could be is they did that to make their own assessment about whether this person was denied the right to a fair trial.
All right, let me ask you a question then in a different way. Can
Sure.
you tell me how the judge's comments constituted a weighted assessment of the evidence that require reversal?
Well, going to the comments, Your Honor.
Right, she says the case is 4 years old. She talks about the fact that one of the children had only been in the care of her parents for 7 months, the oldest for 2 years. She talks about lack of engagement. She talks about violence in the home. She talks about parenting style, anger management, open charges. And then she says, I haven't heard anything yet. I will hear the rest of the evidence from the department. I will hear because neither party filed a witness or exhibit list, so I expect they don't anticipate to offer any exhibits or any other witnesses. Child's counsel didn't. So the only evidence I'm going to have before me is what the department is presenting. Everyone is subject to cross, but I would encourage you to use the lunchtime to reevaluate whether or not those agreements might be the appropriate resolution in this case. Tell me how that constitutes a weighted assessment of the evidence.
Well, I suppose it constitutes a weighted assessment of the evidence in the sense that all it did was point out all of the negative things that both of the parents at that time had done. It didn't point out any of the positive things. It didn't point out the father's relationship with the girls. It didn't point out his claim that DCF had not contacted him for 2.5 years. It didn't give him the opportunity to present his version of the facts. Father, although he didn't put on any witnesses, he testified, and he had the opportunity to present his case through his own testimony. And that was damaged by the judge simply focusing on all the negative things. Yes, there were negative things, but some of her assessments were incorrect, as I pointed out in my brief, and some things did not consider all of the facts. The judge, I should point out, in her style of findings, makes a lot of conclusions throughout her findings. She doesn't really say, father did such and such on this date, then on this date something else, then on this date, and as a result, I conclude later on that, father was unfit, or father did this, or father did that. That's not the way she does things, did things.
But that doesn't mean that that's not, they're not supported by the facts, right? That's sort of her way of doing.
Right. It would be nice if she explained how she came to those conclusions then, because you're required to then guess or go through the transcript or go through the entire record to see if there's enough there to support her facts, and it's a guess as to whether she did that. I don't know. I don't know specifically what was going on in her mind. She's required to write those things down, and she didn't do that.
Well, she did make findings of fact, correct? And then she then says, well, these facts indicate, support that he's not fit to, parent the child because of his unaddressed and unacknowledged, domestic violence, or as failure to engage in services, or whatever, whatever the evidence is, right? Mm-hmm. So the evidence, you're not quarreling with her actual findings, for the facts, correct?
Well,
that you're saying you don't like the way she sort of wrote it up.
Well, again, Your Honor, respectfully, I don't believe that this is a question of whether I'm not quarreling with them in the sense that we would normally quarrel with them in a normal appeal, where this is just whether she made an error or whether she abused her discretion. I'm quarreling with them just to point out that there are other ways to interpret what was done. And so by explaining that, I'm hoping that this court will understand, or that I am conveying clearly, that if she was biased, you can show bias by pointing out there are other ways to explain these facts that she wrote, or that they weren't quite as clearly accurate. I think you have to put her findings more under a microscope in these circumstances if you believe that there's a possibility that this father was prejudiced. So that's all. I do want to, I think I've made all of my points from your questions, but I did want to point out it's a very small point, concerning one of the court's findings, and it was that he had refused to answer questions. I read through all of Father's testimony, and I did not see any indication that he'd refused to answer a question. There was one question that he was asked, and that was how much money he had made, and he said, I don't want to answer that question, and the judge said, well, you have to answer the question, and he said, okay, and then he gave the answer. So things like that should raise a concern, I hope raises concern with the court sufficient to support the father's appeal. Thank you all very much.
Thank you very much, counsel. Are we going to hear from the department first? Mr. Price for 7.5 minutes. Let's just reset the clock. Thank you. When you're ready.
Good morning, Your Honors. Matthew Price on behalf of the Department for Children and Families. The department is asking this court to affirm the decision of the lower court that terminated father's parental rights. The trial court's decision was the correct one in this case. It was not an abuse of discretion to terminate father's parental rights, and there was substantial evidence to support the judge's findings. The The judge's reasoning was solid based on father's history of violence that included domestic violence, but not exclusively domestic violence, mental health issues that went essentially untreated. That was a delusional disorder that the court found triggered his violent reactions to things. Father was involved with some services from the department, but there was no meaningful change as a result of those. And I think what captures father as a parent that made an impression on the court was the May 2018 arrest of mother, where mother had destroyed his car. He was arrested. The children needed to be cared for. They were present, and rather than take them in, rather than take his children into the house, he turned them away. They had to be cared for by an uncle. That's the nature of the evidence that the court
I think we
was
all understand
considering.
what the evidence of unfitness was in this case, but there's the preliminary question of, did the judge's comments somehow constitute an assessment of the evidence? Was the father denied a full and fair hearing? So could you speak to that?
Yes, the judge did not prejudge the case. The language that was used, that was cited in the briefs, it is not a weighted assessment of the evidence. As I see it and said in the brief, it was a summary of what the court had heard at that point. And I believe it's TIA says that issue spotting is acceptable. And I think that's the extent of what this was. By the time that the judge spoke about the settlement, she'd heard two witnesses from the department, the supervisor and the ongoing social worker. And the department was the only one putting on witnesses on this case.
The father was testifying, right?
He did testify, yep. And she was clear that she was leaving open her mind to hear his testimony.
Do you think the issue was preserved, given the fact that there was no objection, a counsel at trial didn't ask the judge to recuse, and
Was the issue preserved? I don't think it was. I think it was waived. But if this court gets to the merits of it, I would say that by the time that the judge had made the statements about settlement, she'd already heard evidence about the domestic violence, about his inconsistency in services, his housing instability, not visiting with the children for 2 years, that there was no observable changes that he'd made for the services he was involved with, and homelessness, mental health, and domestic violence continued to be an ongoing concern. That is what had already come in when she brought up the settlement idea. And given that context, and I think that it's the context that has to be considered in these cases to determine whether a judge has prejudged the case, doesn't get to that level. What is across the line is something where the judge says, I've made up my mind halfway through the case. That wasn't this case. But the case law says that even where a judge does a weighted assessment of the evidence, which the trial court shouldn't do, where the evidence is so substantial, it's essentially harmless error, and the result would be the same. The language that the judge used in this case was not even to the degree that the language was used in the Tia and Georgia case. And in those cases, the court found, at least in the Tia case, that it was harmless, it was not reversible error. And so I think that it wouldn't be in this case either, because the degree is much less. I would just say that from the Georgia case, this was not a situation where the trial continued as a useless ceremony. It was the father got a fair trial, and the judge did not prejudge, as he asked, as father suggests. And we would ask that you affirm the lower court's decision. If there's not any questions.
Well, thank you very
Thank
much. Attorney Kling, on behalf of the children.
Yes, Your Honor. Good morning, may it please the court. I am Lisa Kling, and I represent the children. I've represented them on appeal and also at the trial level. So I've been with these children since the first CNP in
Thank
this
you
family.
for that. That's somewhat unusual.
I just wanted to touch on two areas specifically that haven't been addressed. I concur with the previous argument by counsel as to whether the issue was waived and as to the unfitness. I did want to raise one thing. I think there's an argument that was made that somehow that this assessment of the evidence led to her looking at things in a particular way. And I want to stress, and I can't stress this enough, is that what really sank father was his own testimony and his presentation. His presentation, as noted in her findings, at points didn't make logical sense. Then when he would be asked a question, he would remain silent, hold long stares as a recipient of those stares, and at times not want to answer the question. These were all listed in her findings as to his presentation, his smirking, his stares, his pressured speech, which she found consistent with the prior representations of the social worker about him being paranoid and aggressive and delusional. So that is the one thing I think that really, the bottom line is he was not a good witness for himself. And all the other evidence that was before the court besides that, that kind of, in a way, doomed him. As to these children, I just want to make it clear to these court that these children are special needs children. The youngest in particular is probably the most special needs. She's autistic, she's behaviorally challenged, a lot going on with that little girl. Her sister is better off, but she also has special needs as well. They're both IEP kids. They're with their foster parent, who is their aunt, who is the adoptive resource. And they have special needs that go above and beyond what normal kids would have. They require multiple services in the home. And this is daily services that are in the home to deal with the youngest child.
One of them requires ABA therapy.
Correct. And in fact, they're in the home first thing in the morning, they're in the home after school, and then there's a number of other providers as well. So there's a multiple level of providers in this home working with this family to ensure that these girls get the services that they need. The foster parent is the person who put all these things into place. She's a good advocate for them. So these children require parenting that go above and beyond what is normally required, Your Honor. And the father falls short of being able to do that. And in fact, Your Honor, throughout his involvement in these cases, he's been kind of on the side and waiting for mom to do what she needs to do and then taking advantage of. That's how the first CNP got dismissed, because mother did some things which got her, her oldest back. I think the youngest was born. It wasn't a part of that CNP. And then, of course, in this case, that didn't happen. So 6 months before trial is when he started to do services which he didn't think he needed, according to his testimony.
Can I ask a question about his sort of resuming visits after 2 years, right? The case was 4 years old. 2.5 years of not visiting. And the father, at least in his brief, blames, well, and I guess in his testimony, said that it was DCF's fault for not.
Which I don't think the court credited.
Right.
And And then there were problems after they resumed. I mean, before when he started coming around again asking for visits, I know the testimony was that the foster parent, that they were working with providers to try to let the children know what's going to happen, how to do this in the best way for them, because it's been a big chunk of their lives that he's been absent. In fact, the last visit that he had before he went, this was before COVID and lockdown, it was his birthday, and the girls had made him cookies. And then they didn't see him for 2.5 years. So.
And then there's been some concern about post-visit
Correct.
dysregulation.
I mean, there was a concern, I think in one of the first visits, he was upset with her because she didn't call him daddy. So that, of course, upset the child as well. And then on another visit, he was telling them they're coming home soon. So they would have all these behaviors after a visit, some of them defiant, some other types depending on the child, which had the behaviors, different behaviors for different children. And she literally would plan it. They made a decision to have the visits on Fridays so that she could stack the weekend with so many activities that the children would be distracted from what happened on Friday, and so that it wouldn't affect their school. So that's how that was dealt with. But again, this was six months before trial when that started happening again, roughly 6 to 7 months. And the behaviors continue throughout. So these children have been in care an extensive period of time. And if we're even just looking at this case, Your Honor, that case was a 2018 case where we're going 8 years now.
Was there a previous trial date set before the trial in 2022?
I think a lot of the delay initially was because of COVID, okay? And so trials weren't happening because of COVID. And then there was another appeal before this appeal, which actually delayed it as well. So we are where we are. The children have been with this particular foster parent since she was the foster parent in the first case and in this case, Your Honor. So they've been with her quite some time. It's their TT, as they refer to her. And these children, permanency needs to happen for these children. It's been way too long for them to be dealing with social workers and everything that comes with that and comes with being a child in DCF custody. And so I would ask this court to affirm the decision of the trial court.
Thank you. Thank you all. These are always very difficult cases. We appreciate your advocacy on behalf of all the parties. The case is now under advisement. Thank you. Our next case is LOIS WRIGHT versus George ZANTUHOS. I'm sorry if I've mispronounced that. Docket number 25P857. Good morning.
Good morning, Your Honors. My name is Attorney Jerry Phelps, and I represent LOIS WRIGHT, the appellant. May it please the Court. For a decision today, Your Honor, is three basic issues. Did the Court err when it failed to find that the will of Mrs. Helen Earle controlled the disposition of these joint accounts at issue? The second issue is, did the trial court err in the assignment of the burden of proof? And last but not least, did the trial court err in not finding that the accounts at issue were convenience accounts, considering the overwhelming evidence to the effect that they are convenience accounts? The trial court erred in not finding the will controls the disposition of the accounts at issue. To do so completely nullifies the provisions of the will treating such accounts and belonging to the estate, and I cite Miles versus Capel.
Could I ask you a question? In your brief at page 11, you say, if the defendant or any joint tenant was to take the joint account balances by survivorship, it would have so stated in the will filed for probate, but it does not. And you don't cite any case law for that authority. My understanding is there are lots of instruments, including accounts that are joint with right of survivorship, that are created for the express purpose of avoiding probate, and I can understand why one would want to avoid probate. So what do you rely upon when you say in your brief that these accounts, if they were JTWRS, should have said so in the will?
Exactly. Paragraph 4th of the will explicitly includes all bank accounts in the estate. That's what I'm relying on, and I'm citing
But you're
Miles
saying
for-
as a matter of law that if there are accounts that are to pass outside of probate, the will has to say that. What law do you rely on, or what statute, or what under the Uniform Probate Code supports that proposition?
That's really not what I'm saying, Your Honor, and I apologize if I'm not clear on that. What I'm saying is this, is the question in this case is what was the intent of Mrs. Earle in placing Mr. ZANTUHOS on those accounts? What was the intent? I've drafted wills before, and if the intent was that Mrs. ZANTUHOS was to take those joint accounts by survivorship, I would say so in the will, to make it perfectly crystal clear what my intentions are with respect to those accounts.
Do you have to?
You don't have to.
I mean,
but
if I
it'll-
put a house in trust to pass outside probate, do I have to put that in the will?
Oh, absolutely not. It has a separate.
You're
it's
just
stated-
saying belts and suspenders. It would have been better to have included it in the will. But somehow you're suggesting that there's a legal error because it was not in the will, and that's where I'm confused.
The legal error comes in the fact that the will does state that the bank accounts are in her estate. That's where the legal binding comes into play.
Okay,
The-
so on
the
day
will does
one, they're
say-
in the estate.
I'm sorry, Your Honor.
Let's say on day one, I create a will, and I have 3 bank accounts, and I say in my will, they're all going to Judge Meade. Don't get excited, they don't have much in them. And 6 months from now, Judge Meade and I have a big disagreement, and I said, you know what, they're not going to him. I like Judge Tan better. I'm going to the bank with Judge Tan, and I'm putting them with joint rights of survivorship to Judge Tan.
I'm suing.
You're going to sue me, we know this, but why is what I said about Judge Meade controlling over my subsequent action, assuming that I had capacity, there was no undue influence, et cetera, et cetera?
It's still a question of intent. Now, we don't know that. I mean, I trust you, Your Honor, that this has taken place. But we're in a vacuum here, okay? We don't know what was stated, okay, what the intention was.
I mean, who?
Mrs. Earle, as an example, she had 2 prior wills, and the current will, they all treated the accounts at issue, or bank accounts, as part of the estate. They were drafted by her long-term attorney, Savas Hanses, okay, and nothing had ever changed. That's all the evidence that we have. We don't have any other evidence, and actually, incidentally, the only evidence introduced by the defendant, George ZANTUHOS, to the effect that the accounts should be his, were the hearsay statements of Mrs. Earle that he said, she said that he said that she said that he should, that he was to have the accounts. The court, over my objection, admitted that into evidence, and I reserve that for appeal, Your Honor. There's no way, that's the only evidence. I can summarize the evidence that came in.
But we have it, and I guess part of my question is, the will talked about, I think she called them, it was an odd term, bank deposits versus bank accounts. But the accounts in question here that went JTWROS were not specifically listed, right? She talked about Cape Cod bank deposits. How do we know that those are the same or different from what ultimately went outside of probate?
We don't, and unfortunately, they probably should have listed the account numbers. However, Attorney Hanses, as an astute attorney, I'm sure that he was, I mean, he obviously had to have questioned her about those, and they were continued on uniformly. Each and every will treated the bank accounts, bank deposits, as part of the estate.
So after you draft a will, let's say you put 3 bank accounts and you specifically put the numbers. They end in, 567, 789, 123. 3 years later, will's in place, I open up a new bank account that ends in ABC. Do I now have to amend my will?
Mrs. Earl, the evidence showed that she was a very competent person, and she had no cognitive ability. She was 102 when these accounts were set up, but she was bright. And if she had an intention to change that, wouldn't she have talked to her lawyer and said, because she knew Attorney Hanses very well, wouldn't she have talked to him and say, listen, I'm putting George's name, Mr. Santuho's name on these accounts. You've got to get this will straightened out to reflect that intent. Should I go on?
It's your time.
So, again, the trial court erred in not assigning the burden of proof to the defendant, who was a fiduciary to Helen Earl at the time of the transactions at issue. Okay, that's one thing. But if I look at even what happened overall at the trial, what came in? I contend that the trial court erred in not finding the accounts to be convenience accounts, in that, in addition to being designated as belonging to the estate at paragraph 4 of Helen's will, one, he never contributed to the accounts at issue. Mr. Santuhos admitted this. He never felt that he could withdraw funds from the account for himself. He admitted that he was told by Helen he could use the accounts to pay her bills. Further to that, other than to pay her bills, Mr. Santuhos testified that he had no idea, he testified to this, he had no idea why Helen Earl put his name on the accounts at issue. On that evidence alone, I submit, Your Honor, the trial court should have found that the addition of the defendant's name to the accounts in question were for the sole convenience of Helen Earl, the testatrix.
But there was no need, correct, for her to put him on for convenience purposes, because he already had the ability to write checks, right, and to withdraw funds from those accounts because of his role as a power of attorney, right? And as you pointed out, she was very vibrant, even in her older age, right? She was still doing a lot of things. She changed her will 3 times. She was writing checks even after he was added, the defendant was added, correct?
Well, after she did have a couple of falls, and she was 102 years old when she established these accounts. So it'd be normal that she would say, well, you know, at some point I could be disabled.
Right.
You know, so I would like to designate George as, you know, somebody that can take care of things, keep the burner burning in my house, keep the oil burner filled, pay my bills, pay my taxes, keep a roof over my head. It's logical that she would put him on the accounts for that convenience. My client lived in California, so she wouldn't have necessarily been appropriate for that particular role. But I can see why that she would do that. And George, actually, by signing the checks as power of attorney, in my mind, shows that he knew that that account was not his. It's almost as a veiled, because he could, if he really felt he owned that account, he didn't have to sign his POA. Yes, Helen had 2 falls and was over 100 years old when the accounts were established. ZANTUHOS admits that Lois was like a granddaughter to Helen, my client. Helen's will designates Lois as a specific legatee, as well as the residuary legatee under Helen's will. Helen had executed 2 prior wills drafted by her long-term attorney, Savis Hanses. In each instance, the provision of her wills uniformly bequeathed the bulk of her estate to her niece, my client, her niece, Xenia Wright Marks, my client's mother, who has subsequently died, or in the alternative to my client. Attorney Hanses drafted the will submitted for probate and also served as a notary. Attorney Hanses died on July 30, 2018. Almost immediately following Attorney Hanses' death, the defendant undertook to substitute himself as a joint owner on the Cape Cod accounts at issue in this case. I submit that paragraph 4th of the decedent's will admitted to probate specifically states that the estate is comprised of, among other things, certificates of deposit, money market accounts, retirement benefits, and bank deposits, which are what are at issue. There is no indication anywhere in the will that said accounts were held jointly, much less that a joint tenant, if any, would take by survivorship. The will admitted for probate, as well as 2 prior superseded wills drafted by attorney Savis Hanses, her longtime attorney, one in 1996 and the other in 2003, consistently declare the certificates of deposit, money market accounts, retirement accounts, and bank deposits belong to the estate. ZANTUHOS admitted at trial, and the signed documents show, ZANTUHOS admitted this at trial, that ZANTUHOS went to the bank with Helen Ural and participated in adding his name to the accounts at issue in this case. That's clear.
The judge found, though, right, that it was actually Helen's initiating this, that it wasn't the defendant's.
I don't know how we could have necessarily found that when the testimony itself said that he went to the bank with her. The documents are clearly signed by both of them at the same time.
They went there together, but the actual idea of adding him was initiated by her, not him.
There's no evidence of that at all in the trial. None whatsoever. The only evidence actually that was elicited from Mr. ZANTUHOS was that Helen said, hearsay, and I objected uniformly to that Helen said that this money was to be his. That's it. If you sum this up and you look, let me see. Yeah, if you look at the next point I was going to make, actually, the defendant admits he never contributed to the accounts at issue. He never felt he could withdraw funds from the account. Never felt that. He never paid income taxes on interest earned from the accounts. And Helen told him he could use the accounts to pay her bills. That came in, I didn't object. In fact, other than to pay her bills, ZANTUHOS testified he had no idea why Helen Ural put his name on the accounts at issue. He testified to that. And the court has the entire transcript of the trial at your disposal, as well as the trial judge's detailed findings of fact and rulings of law. You can make decisions here that are contrary to his. With that, I'll rely on my brief, Your Honor.
Thank you. Attorney Hodgman?
Good morning. May it please the court. Rachel Hodgman on behalf of George ZANTUHOS. As you've heard this morning already, Mr. ZANTUHOS is the nephew of Helen Ural, the decedent in this matter, and the cousin of Lois Wright, who's the plaintiff in this matter. Essentially, Mr. ZANTUHOS is asking that you affirm the lower court's decision with regard to these 4 accounts. These 4 Cape Cod 5 accounts, 3 of which we know were in existence as of September 21 of 2018. At the time, Mr. ZANTUHOS had, for almost 8 years, been named as a power of attorney, as an attorney in fact, for Ms. Ural. Given that instance, there was essentially no need for Ms. Ural to add Mr. ZANTUHOS, as the court has already, and the panel has already pointed out. So in this specific instance—
And Ms. Wright did take under the will, correct? She was not excluded, and it was a substantial take.
It was a substantial take, Your Honor. Yes, that's correct. Over 8,000 shares of ExxonMobil stock, and there's also a subsequent bank account, which could have potentially been included in this vague statement in the will with bank deposits that Ms. Ural owned, that Ms. Wright will also take at the conclusion of, or did I'm not sure if she did at the conclusion of the estate matter. Forgive me if I'm not sure.
Just so I'm clear, there was no undue influence claim brought below, correct?
That's correct, but the judge did direct it and did address it in his
This was
findings.
conversion and breach of fiduciary duty.
That's correct. Two versions of breach of fiduciary duty, one against Mr. ZANTUHOS' power of attorney, and another as personal representative of Ms. Earle's
And
estate.
do you agree that if there is something that is going to pass outside of probate, for example, the JTWRS accounts here, that does not need to be stated in a will and the code does not require that?
That's correct. Under Master General Laws, Chapter 190B, Section 1-601, it specifically states that in that particular instance, it would be a non-testamentary transfer. There are also two cases that we cited in our brief, Petition of Smith, as well as Holyoke National Bank versus Bailey, which indicates actually that a will and language in a will cannot override the joint tenancy holding of bank accounts, which in my opinion specifically addresses this issue, Your Honors. And just kind of to discuss as a blanket, Ms. Earle, clearly, as we've indicated, she had 3 different wills drafted on her behalf. There are specific bequests with regard to stock. There are specific bequests with regard to property, personality, and real property. And in addition, she references this blanket statement in all 3 of the wills, which certificate of deposits, bank deposits, stocks, and money market accounts. Actually, in her last will, she adds retirement benefits because at that time some time had passed. So, but it's a blanket statement. It does not specify Cape Cod 5. It does not specify Citizens, another bank account she had. It does not specify Rockland Trust, yet another bank account my client was unaware that she had. So to indicate that specifically because we don't itemize bank accounts, therefore she cannot change her mind or dispose of them in a different way, certainly in a joint tenancy manner, in my mind and in my opinion, is outside of public policy or what would be appropriate and or essentially contradictory to the point of a joint tenancy account with rights of survivorship in the first instance. And essentially, so that's our primary position with regard to this blanket statement and the will.
Can you briefly address the burden shift?
Sure, certainly. So in my opinion, Cleary is distinguishable from the facts of this situation. Yes, we're both dealing with certain circumstances with fiduciaries. However, I think given the court's language, specifically in Cleary, it indicates the fiduciary can take precautions to ensure that proof exists that the transaction was fair and that his principal was fully informed, and he is in the best position after the transaction to explain and justify it. In that specific situation, it's clear that there's an intended overt action that should be taken on the part of the fiduciary, thus to bring about the transaction and the benefit.
And thus sort of the analysis of the trial judge about the lack of undue influence.
That's correct. That's absolutely correct, especially because that's the specific language that Cleary references is an undue influence or fraud, right? Essentially a will or document or other transaction that's procured on fraud or undue influence. Essentially, in that particular instance, they're indicating that a fiduciary relationship owes an extra care of duty to the principal, which in Cleary is essentially addressed in this language that I just stated, which I believe means that they needed to take an extra step and or there needs to be some overt action on the fiduciary, right, and purposes of protecting the principal. But if you move on to Redding, which is an unpublished case of this court, but also Rumpelakis, forgive me if I'm mispronouncing that, it's essentially analyzed further, and the court's indicating it doesn't mean any interaction or essentially any transaction that would benefit the fiduciary with regard to the principal. It's essentially indicating that there needs to be an additional action or some overt action taken by the fiduciary to bring about that specific instance. Right? In this particular instance, there is actually evidence Mr. ZANTUHOS testified to the fact that Ms. Earle directed him to sit down at the bank. These were also routine bank visits. Mr. ZANTUHOS testified that he was unaware prior to this routine bank visit. They were occurring weekly and oftentimes bi-weekly. Mr. ZANTUHOS indicated that he was unaware in advance that this was going to occur. And also, I do think there were 4 forms that were signed, account agreements. Yes, Mr. ZANTUHOS' signature is on the agreement, but if we want to say involvement, that's really as far as we're going. He signs on the dotted line. There's a second document that was signed by Ms. Earle and solely by Ms. Earle on September 21 of 2018. And that's a change of ownership slash title form, and that wasn't entered at the time of trial. And in that indication, it indicates 3 different accounts that are held by a single owner, and then below it indicates rights of survivorship with those 3 different accounts, with Mr. ZANTUHOS listed with her. So not only did she sign the account agreement forms, which indicate clearly, the box is clearly checked with rights of survivorship, and below joint tenants, or excuse me, tenants in common, no survivorship, which was not checked, she also takes upon herself to sign in front of the bank this required change of ownership form. So I would indicate that had Mr. ZANTUHOS been directing that, he would have signed it as power of attorney, and or bank personnel. It's noted in the testimony that these were routine trips to this bank. It was a local bank. They would go routinely to the grocery store, to the bank and the post office. I would expect, though it's an inference I'm not asking this court to make, that someone in the bank or one of the bank personnel, if they believed that something was occurring out of pocket or improper, that someone would have stepped
They
in.
have mandatory reporting requirements, right?
I assume so, correct. And I would also expect that if there was some concern with Ms. Earle's cognition or what in fact was occurring, they arguably would have been the best people to make that determination. But again, I understand that's not before the court, and I'm not asking you to make that inference. And so essentially what that does is brings me into the argument with regard to convenience. There are 4 accounts at issue, 3 of which, as I indicated, were in effect, or in existence rather, as of September 21st of 2018, when Ms. Earle initiated this transfer. One was a certificate of deposit account. There's no purpose or benefit for a certificate of deposit account to be passed for convenience, for Mr. ZANTUHOS to be added for purposes of convenience. The other 2 accounts were money market accounts, one of which is account ending in 9714. In the judge's findings, he indicates that there were, I believe it's 81 checks that are written during this period of time, 3 of which are signed by Mr. ZANTUHOS. Those 3 checks are signed under the power of attorney in July of 2018. The adding of his name on the accounts doesn't occur until September. So as Your Honors recently pointed out, there was no reason for purposes of convenience that Mr. ZANTUHOS would be added to a certificate of deposit account, and certainly not to the other 2 money market accounts that were in existence at that time. A few months later, April 4th of 2019, there's a 4th account that's opened, and it's a second certificate of deposit account. And that one's created newly. It was not previously in existence. And Mr. ZANTUHOS is added to that account as joint tenant with rights of survivorship, excuse me, joint holder with rights of survivorship as well. So again, I don't see the purpose in these particular instances. There was already a power of attorney that had been in effect for nearly 8 years. Mr. ZANTUHOS was already operating under that power of attorney and signing checks when necessary on Ms. Earle's behalf. And I think, unless there are further questions of the panel, I've concluded.
I don't see any. Thank you very much.
I'll rest on my brief.
The case
Thank
is
you.
under advisement. Our final case this morning is John Doe number 528260 versus the Sex Offender Registry Board. I remind counsel that the case is impounded, so please use pseudonyms. Mr. Gauthier, good morning.
Good morning, Your Honor. Congratulations on your promotion.
I haven't seen you, I guess. Okay,
This is the first time that I've seen you since your promotion. I say
You
congratulations.
assume it's a promotion.
I say congratulations knowing it's probably a lot more work. So
It's just because Judge Meade gives me a hard time.
That's my role.
Your Honors, I'd like to jump into issue number 2, which deals with our contention that
On issue 1, you didn't raise the checklist argument in Superior Court, right?
The argument was not raised in Superior Court. I understand that there are going to be a number of arguments that prior counsel who handled the case at the Superior Court level did not raise. However, the one thing I would say to that is these aren't cases like criminal cases. These cases are going to be reheard and reheard and reheard because our clients get a new hearing every 3 years. So although an issue might be waived for purposes of the appeal, it's always helpful to board counsel and to counsel for an offender going into a new hearing having evidentiary issues resolved. I do understand that prior counsel didn't raise some of the evidentiary issues, and I would also point out that it has been 3 years since the hearing in this case. So at this point,
It's his hearing.
His hearing
Stayed for this, right?
he can't petition for a new hearing while this is pending. So the importance of this case is not essentially to get him a new hearing because our clients are entitled to that every 3 years. The importance of the case is perhaps to have some issues addressed so that when he goes before the hearing examiner in the coming year, these don't have to be relitigated. So if the issues aren't reached during this appeal, they'll have to be reached by the hearing examiner, Superior Court, and Appeals Court on the next go-around. And these cases, as long as my client is alive, lives in Massachusetts, and isn't relieved, he will be appearing before this court every 3 years for the foreseeable future. But in terms of the fact-finding, I think the board would concede that if there was insufficient evidence of penetration, then the hearing examiner misapplied factor 19. And in terms of victim 2, if there's insufficient evidence that that occurred, then there's a misapplication of 5 factors that deal only with victim 2.
But the not guilty on the index crime does not necessarily mean for purposes of this that there's no penetration.
Different standard of proof. Criminal trial, of course, is proof beyond a reasonable doubt. An administrative hearing is preponderance of the evidence.
All right, so tell us why the hearing examiner erred in finding penetration.
So for victim number 1, the factual record, luckily for the court, is small in terms of the police reports for victim 1 and 2. Essentially, we have pages 33 and 32 of the second record appendix. We have a statement made by a 7-year-old victim that the doe put his balls on her butt. She doesn't say penetration. She's 7 years old.
And that her bottom hurt.
And that her bottom hurt.
And that his body was moving up and down.
His body was moving up and down.
And that something was very hard.
Yes. The victim was brought to the Bay State Medical Center where they did an exam. These are doctors and nurses trained, and they, in their opinion, their medical opinion, with their training and experience, did not believe there was penetration, and as a result, did not order a sexual assault.
They didn't find corroboration of penetration. They didn't say there wasn't penetration.
According to the police report, written by the police officer, quote, they did not feel there was any penetration. There was no plan for a sexual assault kit. That's page 37 of the second record appendix. They did not believe there was penetration. The hearing examiner, on the other hand, leaves it up in the air that penetration was not conclusive. The hearing examiner doesn't actually quote directly from the police report, and instead of saying what the professionals found, says that it was inconclusive. The professional opinion was there was no penetration. And that's essentially the entirety of...
Does the hearing examiner have to credit that?
Medical professionals over a 7-year-old who doesn't say... No, a hearing examiner, just like a jury, does not have to credit. But in this case, the hearing examiner did not discredit it. He actually changed the language in the police report to come to the conclusion that he had made that there was penetration. There was nothing in the hearing examiner decision that says the experts in this case say there was no penetration. I find otherwise because of this. He changed what the expert said and said it was inconclusive. So the hearing examiner doesn't actually address the veracity or the integrity of the statements by the healthcare professionals. The hearing examiner essentially glosses over them. And that's essentially it. The only other part of that factual scenario is that when the mother reported it to the police, she did not say that there was penetration. In terms of the second, there's a police report at pages 63, 64, and 65 of the second record appendix. Here we have the hearing examiner determining that there was a sexual assault that occurred on the 4-year-old victim. And again, the hearing examiner essentially says, the victim has no motive to lie, and it was corroborated by the fact that they were found in the bed, and the 6-year-old said that the 4-year-old victim was rubbing the back of Doe. However, the statement that there was a sexual touching, which is necessary for there to be a sexual crime, was made to a family member after intense questioning. Then the 4-year-old child was
You say intense questioning, and you say in your brief that the victim was pressured, but where's the evidence of that?
In the police report, there's evidence that the family members repeatedly, directly asked specific questions, did this, did this, did this,
Right.
did this.
Right.
And then it was a family...
How do we read on that cold record that it was intense, let alone pressured?
How can a hearing examiner assess the credibility of a witness or a medical professional or anybody on a cold record. There's no way.
I'm just saying you've added characterizations to the questioning that I don't see how they're supported.
It's apparent that multiple family members questioned the two girls specifically on whether any sexual contact.
I'm sorry, help me with the record. Other than the mother and the grandmother, who else?
That's the two people.
So that's where your multiple comes from?
Yes.
Okay. So two people questioned her?
Yes. However, when they took victim number 2, the 4-year-old, to an expert interviewer, for a forensic interviewer, the 4-year-old was directly asked to say what happened, and she was asked if she was hurt, and she said no. So she's being asked by a professional forensic interviewer, and now suddenly it's a very different story.
Well, but I want to go back to the medical evidence. Certainly the child was examined, but there was no rape kit, right?
They chose not to have a rape. The medical professionals declined to do a rape kit because they did not believe penetration occurred. That was why the rape kit was declined. The medical professionals, the doctors and nurses, made a judgment call based on evaluating the 7-year-old that there was no penetration and there was no ejaculation. And without those findings, initially, they decided that a rape kit was not warranted. In terms of circling back to the second case with the 4-year-old, I note in both instances, the hearing examiner says, these people have no motive to lie. But a person can recount things incorrectly with no motive to lie. Memory requires encoding, storage, it requires retrieval, and these are very young children. And here we have a parent. The child was 4? The second child was 4 years old and never disclosed a sexual touching to anybody, allegedly anybody, but the mother and the grandmother. When spoken to by forensics, it didn't happen. So preponderance of the evidence, of course, this court, like the hearing examiner, is going to have to, read the 5 pages of police reports and determine, based on preponderance of the evidence standard, was that enough to establish that penetration occurred in one instance, and in the second instance, did a sexual assault occur at all? Moving on to number 3, we have application of repetitive and compulsive behavior. And as I'm sure this court is aware, part of that regulation under the old regulations has been struck down. It's not enough to have 1, 2, 3, 4 offenses. That's repetitive, it's not compulsive. What you need is an intermediate act, something to put the offender on notice that he has been found.
How about his prosecution involving victim number 1?
Well, in this case, my reading of the record is that he was charged in 2015 with...
Victim number 1.
He was never arraigned or brought to court.
But wasn't he confronted by the Springfield police I think it was before the second offense?
It was
correct?
2 years
About
before.
the first.
Mr. Chennai's excellent brief pointed out that you omitted this from yours.
I will concede then that there was an error in the...
So you'll concede that he had notice of the prior charge?
I would not concede he had notice of the prior charge. I would concede that it was brought to his attention that others other than the victim may have been aware that he may have sexually offended. However, the record is not as clear as to whether he was aware.
I'm not sure what you're agreeing to. The police visited him in 2015 and confronted him about the sexual assault on his daughter, right?
Yes, but there was...
Why wouldn't that put him on notice to put him in this category that he committed another offense, having been caught on the prior offense?
This is the first case, honestly, I've had with Factor 2 that doesn't actually involve an intervening charge or conviction. This isn't... I will concede that if you interpret Factor 2 as allowing just a confrontation, then I would concede that we cannot win on that issue. However, if it requires a charge or a conviction, then there was not one of those in the intermediate period.
But why would it turn on whether you've been formally, legally charged or, arraigned or, right? He was told in February 2015, shortly after, right, the incident took place with his daughter. by the police.
Yes. I concede that if that's enough, then the facts support that, and I would concede that this is not a viable issue for Doe on those facts and circumstances.
He was also summoned after he was indicted. I know you make a lot of him not appearing, but...
Well, I guess one inference could be is that a summons did reach him and he willfully failed to go to court. The other inference might be that he was not made aware of the summons and as a result did not go to court. There were subsequent court appearances where he had other charges where he was not arrested on a warrant and brought back to court. So the record is not clear on whether he knew he was summoned, but it is clear that he was made aware by the police department that there were possibilities that he may face charges.
So it was a little unclear to me, and you may not know the answer to this, but the fact that you referenced that he was charged with a separate incident in district court, right? And at that point, I think am I correct with the time frame? He had already been summoned and indicted on the first offense.
He had been summoned
and so and he didn't appear, right? I think wasn't there a warrant?
It wasn't executed. I don't know. I didn't represent him, but he was able to go to a district court in Springfield, get arraigned, and then leave without ever being told that he
it's not clear from the record that actually that there was a warrant that had been...
Correct.
Right.
Either that or they released him to appear on his own recognizance, which I think is very unlikely given the nature of the charges. The last two issues regarding victim impact statement and the diverse victim type, essentially, for the victim impact statement, typically, in my experience, the hearing examiner acknowledges it and says, we understand the effect these types of offenses have on victims. This is frankly the first time I've ever seen a victim impact statement be used as a basis in part for an increase in a degree of dangerousness. I argue that nothing in the regulation allows it. There's no citation to research. Almost all of all of the board regulations cite to actual research, social science research that justifies its use. There's nothing like that for victim impact statement. And for diverse victim type, we're simply arguing that the three articles they rely on simply don't allow the relationship category in this place to be used. I would acknowledge that, of course, these issues were not raised by prior counsel and are waived. However, I would point out that they're likely to come up again at any future hearing involving this particular offender. There are no further questions. Doe will rest on his brief.
I see none. Thank you, Mr. Gauthier.
Thank you.
Ms. Morency? I think this is, for me, the first time we are hearing a case after Attorney Shanai's passing, and so it's kind of a bittersweet moment.
Yes, it's a great loss to the board. May it please the court. Nancy Morency, appearing on behalf of the Sex Offender Registry Board. This case is about whether the Level 3 classification was supported by substantial evidence, and here, based on Doe's conviction, his sexual misconduct, and his circumstances, supported that there were 2 high-risk factors and 8 risk-elevating factors that applied. The decision was based on substantial evidence and proper application of the board's regulatory factors. In regards to the appellant's arguments regarding hearsay evidence, there was 2 victims that had separate hearsay statements that are raised in the briefs. First, the hearing examiner found that there was a high degree of detail in both of the victims' reports. They provided a sequence of events, what Doe said and did, and they also found that the victims had no motive to lie, and victim 2's statement was corroborated. So more specifically, victim 1's statements were found to be reliable because at the forensic interview, victim 2 disclosed that her father put his balls in her butt and on her back. He was moving his body up and down, and the balls felt hard like a rock, and her bottom hurt. That was at the forensic interview. Prior to that, when the mother first wrote a statement and disclosed it to the police, is where that on her back came from. And then that mother had a conversation with the hospital at that point about the on the back. At that point, only based on that, it's per that report, it says that based on conversations with the mother, they then did a cursory exam of the victim and then decided not to do an actual sexual assault kit. So I submit that the forensic interview thereafter that asked the more pointed questions about the actual sexual assault that occurred is more accurate, and the hearing examiner reasonably found that there was penetration based on that. In regards to victim 2's statements, she explained the details, again, very detailed report, and it was corroborated by her sister in the bedroom. So the victim said, yes, I was on the bed because I was rubbing his back because his back and belly hurt, and her sister said, yes, that's why she was there. The mother found the victim on the bed when she walked in. She also saw that Doe, what she believed to be, have an erection at that time, too. So all of that corroborated the victim's statements. And the grandmother then asked direct questions. It wasn't pressured. It even says in the report how she says, maybe this was innocent, and then asked those pointed questions to get this information, because it was a 4-year-old child that maybe didn't have the best communication skills, and she just had a sexual assault against her. So it's definitely reasonable for the hearing examiner to find that the victim may have used words with the grandmother that she understood, that her front meant her vagina, whereas in a professional interview, that might not have come out as clearly because she didn't understand that communication level. So again, the hearing examiner's finding was based on the evidence and it was reasonable. So that supported the application of multiple factors that the appellant raises issue with. First was factor 2. I'm not quite confident that it was conceded entirely, so just to briefly address that, he was investigated and indicted for sexually assaulting victim 1, and that was in 2015. And default issued, so the presumption is that he was aware of it. And as your honors noted, that the detective on February 19th, 2015, spoke with him and informed him of the charges. Factor 2 specifically states that as long as there is time and opportunity between the episodes after they've been discovered and confronted by someone other than the victim, or investigated. So in this case, he was confronted at a minimum. So factor 2, without a doubt, does apply in this case because he was notified by the court based on the default and the detective calling him. Factor 19, as I addressed, it was reasonable for the hearing examiner to find that there was penetration, so that factor reasonably applied, and again, that was just one in all of the substantive evidence that supported that level 3 classification. Factor 21 was applicable here because that's the diverse victim type. Here, the first victim was a familial victim, and the second one was an extrafamilial victim. So if you look at factor 7, that explains the differences in the types of victim relationships. And once you then compare that over to factor 21, it does state that there is a relationship category, that there's a difference. So clearly there was a relationship, and that factor is properly applied. In regards to factor 38, which is the victim impact statement, the hearing examiner was required to review that based on the regulatory language. It was in the evidence. He had to review it, and it would have been an error not to.
Does it go to dangerousness?
It doesn't state specifically, so therefore there's no restriction that, like, some of the factors might say this applies to risk of reoffense, this factor will apply to the degree of dangerousness. Factor 38 doesn't.
Did the hearing examiner apply it for dangerousness?
The hearing examiner did consider factor 38 in regards to the degree of dangerousness. And for dangerousness, that's the severity and extent of harm to a potential victim. So clearly, a victim that resulted from a sexual offense from Doe would be in a great position to say this is how severe an extent of harm that he's going to pose to a future victim. So they properly, based on the regulations and the evidence before him, considered it as to the degree of dangerousness. Overall, the decision shows that it was not arbitrary and capricious. The evidence supported all of these factors being applied. As the appellant noted, it was not raised in the Superior Court, so it should be waived, but in the event this court is inclined to consider it, all the evidence was proved by preponderance of the evidence. There was a detailed explanation of which factors applied, why they applied, and that they were properly applied. The hearing examiner weighed the competing factors and then determined that that supported a level 3 determination. So that qualitative analysis, rather than the checklist approach, was completed here. And the board would request that you uphold the level 3 classification. And if there's no further questions, I would rest on my brief.
I see none. Thank you very much. The
Thank you,
case
Your
is
Honors.
under advisement. That concludes today's session of the Appeals Court. I'd like to thank our court staff, in particular our clerk's office, our court officers, our timekeeper, and our law clerks. We are in recess. Thank you.
All rise.